In this video, I'm just going to take a look at a couple of very useful tools if you're involved in a case, in a legal case, in litigation, and you really don't want to be involved in it. You want to try to settle the case. So let's have a look. Basically, this will be very useful to you. These tools will be useful to you if you are a reluctant party to legal proceedings. That would make perfect sense if you're concerned about rising legal costs, and you should. And you may not be in that strong a position, or in fact you may actually recognise that you're in the wrong and that you're just anxious to settle. The two useful litigation tools that I'm going to discuss in this short video is the Calderbank letter and a lodgment. And the purpose of these devices is to attempt to force a plaintiff to seriously consider settling the case rather than going ahead to the high-risk, high-cost venue of court, be it the circuit court or the high court or the district court. In fairness, the district court is not hugely expensive, but certainly the circuit court and the high court and obviously the Supreme Court are going to be very, very expensive places to go. You could find yourself in a situation where you made a mistake, for example, perhaps in an employment matter or something of that nature. You recognise that you made a mistake, you recognise that you're in the wrong, and you are anxious to settle it. However, the other party seems to be very anxious to get their day in court, and that can be expensive for everybody concerned, but particularly for the losing party. Now, if you're the losing party and you have a weak case, well then clearly you're going to want to try to settle or compromise the proceedings. A Calderbank letter then, that arises from an English family law case called Calderbank versus Calderbank. It was basically a letter that was written, it was an offer that was made without prejudice except as to costs. That is critical. This means that the letter, the offer to settle the case, would enjoy the normal without prejudice protection. In other words, it cannot be exposed or opened to the court. However, if the offer is not accepted and it goes to court, then at that stage the judge can be made aware of this Calderbank letter, and he can exercise a fair degree of discretion when it comes to costs, because clearly the letter was an attempt by you to settle the case and you wanted to do so and made an offer on a without prejudice basis, but the costs question, you were in your Calderbank letter allowing it to be opened to the court. So the likes of this letter, a Calderbank letter, would clearly make a plaintiff think very, very carefully about proceeding. At least it should, and his or her solicitor or legal team would be advising him of the dangers of proceeding. Because if he does not do better than the offer, then he may be at risk in relation to costs. That essentially means that not only will he have to pay his own costs, but he may well have to pay your costs as well from the time that you made the offer, sent the Calderbank letter. So that's a very, very useful tool. Second one is a lodgment. You as a defendant can make a lodgment in court in settlement of the case. If it's not accepted and the case goes ahead, the plaintiff will have to be awarded a bigger sum than the amount that you've lodged. If that doesn't happen, the plaintiff will have to pay your costs from the date of the lodgment. So again, this is a device that will certainly focus the mind of a plaintiff who appears to be unwilling to settle and very, very anxious to go to court, because they would be at risk. If they don't beat the lodgment, they would be at risk in terms of costs, not just their own costs, but your costs. These costs would include the cost of the trial, barristers' fees, solicitors' fees, experts' fees, etc. So clearly the plaintiff would have to consider very, very carefully any lodgment that's made by you. The difference then between a lodgment and a Calderbank letter, well, one is the timing. A Calderbank letter can be made or can be used practically up to the time of the trial. This has been seen in I think a Supreme Court trial in Ireland, or a Supreme Court case in Ireland, where they decided that it was in order to attempt to settle the case right up to the time of trial. So it can be used fairly liberally. The other difference is that the court's discretion is wide in relation to a Calderbank letter. In other words, its discretion in relation to costs is very, very wide, whereas the court really doesn't have much discretion in relation to a lodgment. In other words, If the lodgment is not beaten by the plaintiff, well then the court should be awarding costs to you as the defendant from the date of the lodgment. The other thing in relation to the lodgment is the timing isn't as flexible. There is specific periods of time, specific occasions when you can use it, and that depends on the circuit court or high court and whether it's what type of case it is. So they're two very useful tools if you are a plaintiff, or if you're a defendant in a litigation case, in a legal case. You recognise you have a weak case and you're anxious to settle, and the other party, the plaintiff, appears to be very anxious to go to court. These two tools might be helpful to you or your legal team. My name is Terry Gorry. If you like the video, feel free to subscribe to my YouTube channel and give it the thumbs up down below, either on Facebook or on YouTube or wherever you watch it. Thanks for watching.